Good morning, Your Honors, and may it please the Court. I'm Thomas Burns, and I represent Ms. Wilson. I'd like to reserve 3 minutes. It's one of my favorite appeals that I have going on right now, and I think it raises two interesting issues. The first is whether the notice of claims was sufficient, and the second is, if not, did the trial court err when it dismissed with prejudice rather than without prejudice and granting leave to amend regarding collateral estoppel. Let's look at both issues in turn, and when we do so, I want you to keep in mind the plain language interpretation rule and just first principles of legal analysis. And I feel like my voice is way too loud for this microphone. Is it okay for you?
Not to worry, because I'll make sure that we stay
right.
focused.
Okay, so let's start with the statute, and it's section 768.6a, or .286a, and there's only 5 words that are going to govern this appeal as the first issue, and that's you have to present such claim in writing. Now let's look at what the statute does not do. It does not specify the format of the notice. It doesn't contemplate that claimants will be represented by counsel. It doesn't expressly impose any ongoing duty of cooperation with the sovereign's investigation, and it doesn't even say that the claim must be presented in English. So if we were to look just at the statute and nothing else, imagine that no case had ever been decided regarding the statute, we would win. The notice of claim has been presented in writing.
Well, the statute 6A has 2 requirements. You have to state a claim, and it has to be in writing. And then subparagraph C says that the claimant's date and place of birth and social security number of an individual must also be provided.
That's correct, but
that's about it, right?
In Williams against Henderson, which is from this court, 1996 decision, and which is cited in Vargas against City of Fort Myers, which is Judge Sleeth's decision, footnote 1 says you don't have to provide that in the notice of claims. It can be provided later. So that's not pertinent to this appeal. We're just looking at the notice of claims, and subsection C is not going to be determinative of the outcome. But if you were to say, well, we need to look beyond the statute, we need to look at the judicial gloss that's been put on this statute, the place you would start is this court's decision in Vargas, which is, like I said, Judge Sleeth's decision. And in that decision we said, the cases to date yield no talismanic rule as to the specificity of the notice. But there are only 3 requirements that the cases seem to indicate. The first is that it must be sufficiently direct and specific to reasonably put the department on notice of the existence of the claim and demand. It must be written, which is obviously what the statute says, and then it must also sufficiently describe or identify the occurrence so that the agency may investigate it. So if this was the only decision that we had on point, again, we would win. The notice of claims said, hey, it was written, and then it said, hey, I have a claim that exists. And then it's described that claim. It says, I fell. I hurt my leg on a grate. So if that were the only case, we would win. Let's say that you disagree and you say, well, let's...
Is there any case that says you should lose?
Actually, no. The only case that I saw that came close to that was McGee against Mong or Monge. I'm sorry, I'm getting confused. It's Smart against Mong or Monge, which is, again, one of this court's decisions. And there, they said, well, this notice of claims isn't sufficient because all you did was ask for documents, and you got to present the claim. And asking for documents is not the same thing as presenting a claim. Therefore, this notice of claims is insufficient.
With regard to your second argument, does Judge Altenburn's opinion for this court in the city of St. Petersburg, where he talks about a gotcha, does that apply here?
I think you're talking about Bondersek.
Yeah,
right?
City of St. Petersburg, right?
It is, yes.
Okay.
Correct.
I couldn't pronounce the appellant's name. That's why
we're
I
on the
could
same
pronounce.
page. Yeah, that's the purpose of the statute. That's another case that you need to look at, and that's going...
That's not your best case because that's a consortium claim. I mean, the husband already had a claim pending, then the wife files the consortium. The city had investigated it. It's more of an estoppel type situation.
It's an estoppel case. That's correct.
I don't know that you have estoppel here because our court declined the supplementation of the notice by Jamie Garcia.
I didn't ask for the supplementation. I think it was properly denied because it wasn't filed in the record below.
So you
The-
file this notice, it's got her name, her date of birth, Jean Street, you don't give us a number, or give them a number, it's in the yard, et cetera, et cetera. The city's response is, hey, we're dealing with another lawyer, go away?
Well, I don't know. I haven't read this correspondence, just like you haven't read this correspondence.
Well, it's
It's
in the brief.
It's not in my brief, it's in the city's brief. And in the
Okay,
city's brief is describing that as what was talked about at the hearing, saying, like, there's this correspondence, there's this correspondence. That stuff has nothing to do with the sufficiency of the notice of the claims. It would just have to do with whether there is an estoppel argument here that should be allowed to proceed in an amended complaint. And so the argument there is, look, we've got potentially some real factual dispute, because my client's story is, look, you held the ball. You didn't tell me that there was a problem. And then the city's response is also like a fair point. Like, well, we told your first lawyer that we had a problem. And you didn't give that to us. My view of that is it should go to the trial court should have allowed the plaintiff to amend the complaint to make those allegations about estoppel. That dispute should have proceeded to discovery, and then there should have been a summary judgment motion. And I think that had that happened, the summary judgment motion still would have been denied, because there would have been a dispute of fact, because we would have one factual story and another factual story, and that's why we have juries, and that's why we have bench trials.
So Attorney Garcia's notice, which came first in time, wasn't admitted or attached to anything in the...
It was not. The only
Court
notices...
didn't review it, just argument.
Correct. The only notices that were attached to the complaint were the one that went to the, I think we call it the Department of Finance, because FDOT was sued, and then the one that's pertinent here is the one that went to the city of Tampa. That's actually the only notice that is pertinent to this appeal, not the other notice to the Department of Finance. So that would be our argument as to estoppel is, look, you need to you should have denied this without prejudice, let it go through the normal course of litigation, and have this been resolved at summary judgment. But I'm not going to let go of the sufficiency of the notice of claims. I think it is sufficient, and I think if you were to say, well, Vargas doesn't resolve this, the statute itself doesn't resolve this, then we need to look at other holdings in the other DCAs. And I've pointed out in my brief a number of holdings that indicate that this would be sufficient. Atera against City of Hialeah says you don't have to provide the precise location of the incident. Aitchison against Florida Department of Highway Safety and Motor Vehicles says you don't even have to describe the occurrence accurately. And then Franklin against Palm Beach County says, well, you don't even need to have the claimant's name. And the common thread through all those opinions is, look, you were put on notice. There is something out there. Now go figure it out. And essentially, I think what the between the lines rule is, if you can open a file and you begin your investigation, you've been put on notice, and this should proceed. But let's say you still disagree. Let's say that's not enough. We're not going to follow those decisions. We think this is a distinct situation. As a practical matter, I don't think that this matters, because we have the common law which charged the City of Tampa with constructive knowledge and implied notice that when the notice of claim said Jean Street, it meant her home address on Jean Street. And that's because the property appraiser had a public record that indicated that her home address was at a particular address, which is 1412 East Jean Street. Now the city's response to that is to say, well, the statute doesn't charge us with that duty to go and look up public records. And my response in the reply brief is, well, I'm not saying that the statute charges you with that duty. It's the common law that charges you with that duty. And because the statute is silent as to that issue, when you read the statute strictly, it did not abrogate that common law rule.
And doesn't Otero basically say that too? They do have the duty to investigate and request more information. So contrary to their argument, the onus is on them once they've been notified.
That's correct. Yes. And then let's say, well, actually, that's, I think, the last point for why I think that it's sufficient. I just want to address a couple of loose ends which have to do with the City of Tampa's attempted distinctions of a number of cases. There's sort of two categories of distinctions that the city of Tampa attempts to draw, and it says, well, some of these cases involve institutional knowledge. And so they're saying, well, Vargas involved a municipal employee, Brower involved an agency file number and prior conversation between the counsel who represented both the claimant and the defendant, and Williams involved a sheriff's arrest records. I don't think those distinctions work. I think there are three problems with them. The first is that they're based on speculation that was not expressly stated in those opinions. The footnotes that are in the answer brief say, well, one might expect this, one might expect that. That's not what the cases said, and it's not what they were hanging their hat on in making those decisions. And, well, I guess that's one and two. The third problem is if you can speculate in those cases, you could speculate equally well in this case, and it's highly likely that the city of Tampa has maintenance records for its storm drains. And that could come out in some kind of summary judgment or discovery and summary judgment practice where we say, well, that's great. Probably our claimant called and complained to somebody, said the storm drain is dangerous. Some guy came out and fixed the storm drain in the next couple of months, and we would have that record. Now, we don't know that because we're obviously resolving this on a motion to dismiss where we're just dealing with the allegations, but that could easily come out in discovery and summary judgment practice. The final distinction that the city draws is in this Aitchison case, and there they said, well, Aitchison involved notice of claims that didn't sufficiently describe the incident, but it did describe the date and place, and so that's the bare minimum that you have to do. That's not what Aitchison was saying. Aitchison was saying this is sufficient. It's not that it's necessary, but it's sufficient, and that's a distinction that I think is overlooked. The last 2 points I want to leave you with are on page 6 of the answer brief, the city says that the notice of claims was not consistent with the spirit of the statute. And I think by using that language, the city has implicitly conceded that the city is asking this court to judicially rewrite the statute and include additional requirements that it just doesn't have. We're talking about 5 words. And then the final point is, I'm sorry, did I hear? No. Okay. This is just a notice statute, and so the whole point of it is put the sovereign on notice, and then the claimant and the sovereign, whether it's through counsel or pro se or however, they go address the problem. So what we're asking you to do is to vacate the judgment and either hold that the notice of claims was legally sufficient, or to say that the dismissal of the claim with the case with prejudice was error, and that it should be remanded for filing of an amended complaint that alleges estoppel allegations, and then we'll litigate it through the ordinary course of discovery and so forth. Thank you. I'd like to reserve whatever time I've got left.
Good morning, Your Honors. Kristen Ottinger on behalf of the City of Tampa. And
other than not putting a number of the house,
yes, Judge.
tell me how the city was not on reasonable notice that something happened and they're going to be sued.
Well, Judge.
To so-and-so, Miss Wilson, who lives in Tampa, who's got a date of birth, they gave you the date of birth, the date of the accident, her social security number. Are you telling me that armed with that information, there's no way the city could have found out by pecking the computer keyboard where she lived?
Well, Judge, the position that the city takes as far as the notice requirement goes is not just an isolated response. The court is looking at this one case, but specifically with trip and falls that happen throughout the city, it is extremely common to get nothing more than the date that this happened and the claimant's name.
But the statute doesn't distinguish between the causes of action. It just simply says, put it in writing to the appropriate agency.
I agree.
What else do you have to do?
Well, I think that the claimant, at a minimum, has to give us an idea as to where it took place.
Well, why don't you just call them up and ask once you get the letter?
Well,
there's the lawyer. He's met her. He knows where she lives. I mean, what else do you need here?
Well, understood, Judge, but what did happen, and unfortunately is not in the record in front of this court, is that the city did respond and said, we need additional information.
Which may help his estoppel argument. So
it could potentially help the estoppel argument, at least for the lower court to consider it. But it stops there, because the response was, we cannot investigate this claim, and we need additional information about where this took place. We don't have just a limited number of storm drains throughout the city. And if she had identified, yes, this occurred in my yard on Jean Street, then that would give us some direction at a basic level. And the thing that I feel is important about the argument that we could have looked at public records and made a determination as to where Miss Wilson lived, it still begs the question, was that her yard? We don't know that she's referring to her yard. She doesn't specify. And so looking into the public records, getting an address, sending somebody out there on the heels of us asking them to provide a specific address or at least provide photographs to give us an idea of where this took place, leaves the city in a position of still guessing. And the purpose of being put on notice, of course, is the state is telling the public at large and future claimants how we require you to initiate a claim and eventually a lawsuit.
Yeah, but the statute doesn't say that, ma'am. It says give us a notice in writing, period. And then it says, follows up in C, oh, you'll have to give us the date of birth, place of birth, and social security number too, but it doesn't say that it has to be in the initial notice in writing.
Understood, and that's certainly
But you're
why.
talking about something that's unique to the city of Tampa, and I'm sure it applies to every other municipality. But what you're saying is not found in the statute. It doesn't put any other obligation on a citizen other than to write you a letter and say, she could have handwritten this letter and served it on you and said, I'm cleaning stuff out in the yard, my name is such and such, my date of birth is such and such, social security. Why isn't that enough?
Because I still think it puts the city in a question of guessing as to where it took place. And the point of going...
If there's a deficiency there and your city is being inundated with what you view as insufficient data in order to respond, isn't the appropriate remedy to address it to the legislature, who passed this statute and said, in the past we have sovereign immunity. You, the citizen, cannot sue your governmental agency. The legislature has said, now you can, and all you need to do is do this letter. It's the same body, is it not, that can say, in your letter, you must provide the following specific data. It's within their policy to do that, and they're certainly within their constitutional authority, isn't it?
I understand the
Isn't
court...
that the entity that needs, if there's a problem with the statute of providing you notice, who ought to fix it?
I would agree that there should be some more direction in the statute, but the
And would you
issue...
agree that we can't give you that direction? We can't read into the statute what's not there.
Well, I think other courts have already made a determination that at a minimum, the statute requires the reasonable opportunity to investigate the claim. And for that reason, the city is saying and said at the lower level, we didn't have an address. That's the most basic thing. And with the cases that have been cited and analyzed not only by this court, but other courts throughout the state of Florida, they are facts that can be distinguished, but they also include the argument. When you have an accident, we can locate a crash report. We know the people's names who are involved. We know that, there's a city or a county or a government vehicle involved. There's information for us to go on. When there's an incident involving no city witness and someone writing us indicating that they had an injury that they're pursuing a suit over and won't give a basic address, which clearly was readily available to the person writing the letter, it puts the city at a disadvantage because we can't go and potentially photograph evidence, preserve what the scene looks like at the time, and then 3.5 years later when the lawsuit is filed and we have asked them for more information but have not been given any more information, the attorneys for the city and for any agency are at a disadvantage because there's no, the facts or the evidence is not fresh.
I understand that, but if the legislature thought that the municipality or state agency's ability to prepare for suit was very important, or I don't know which word you'd use, they would have written the statute in such a way that said within X number of days of the occurrence, you shall put notice so as to afford the agency. And here in this statute, they just say send notice before commencing the suit. They have no reference in the statute as to the date of occurrence. So, I mean, yes, in a perfect world, the statute would say within X days of the occurrence, provide the location as specific as you can, but they have not seen fit to do that yet.
Well, I just think that it's important where other courts have interpreted that at a minimum, we need a reasonable opportunity to investigate.
Okay, let me borrow a question from my late friend, Judge Watley. What's your best case?
The best case we have is the Atchison case. I apologize, I left a portion of my documents on the bench when I walked down. But
You need them, get them.
thank you.
You've got
I
time.
appreciate that.
We're not going anywhere. Thank you.
Thank you.
That's out of the 4th District in 2013?
Yes, that is the 4th District case, which basically goes in to analyze the written notice that had been provided in that particular case, and they specifically state that the notice should be sufficiently direct and specific to reasonably put, in that case, the state of Florida or a department of the state on notice of the existence of the claim and demand. And
Doesn't reasonable mean that you have enough information to look it up, or enough information to respond? I just Googled Fannie Mae Wilson in Tampa, and I came up with 1420 East Jean Street. While we're here.
I understand, Judge.
So, reasonable.
Well, reasonable also would apply to Ms. Wilson. Why is she not providing the address?
Because nothing says that she has to at that point.
Well, I feel that the position of the city is that it's not reasonable for somebody to, I'm sorry, it's not reasonable to put an onus on the city to investigate in order to determine where they need to investigate. It almost adds another level or layer to the statute itself.
Well, in Atchison, didn't you need to have enough, which you claim to be your best case? I mean, it involved a trip and fall that mistakenly was referred to as an automobile accident. So if you're looking for an automobile accident and you know something happened at that place at that time, didn't that only give you enough information to investigate what you actually needed to investigate, which was the trip and fall?
Well, yes, with an automobile accident, I would agree that you could investigate that differently than the trip and fall. I understand the facts are distinguishable and slightly different from the facts in this case, but because we have never denied that she had put us on notice of a trip and fall, and it had, ultimately been learned that it was some other sort of injury. So basically, the city's position, boiling it down, obviously is clear to the court that we feel that an address should be provided as it relates to a trip and fall, but in general, something should be provided to give the city the opportunity to investigate, and something should be provided in that written notice that doesn't put the city in a position, or any agency in a position, where we have to investigate the letter to turn around and investigate the claim. We obviously want to respond to claims and potentially have the opportunity to resolve them short of litigation. And without going further into policy about volume and demands on cities and counties and agencies in general, I understand, and it's well taken, this court questioning about, the legislature revisiting this particular statute and reviewing it or potentially changing it to accommodate the concerns. But I do feel confident in this case that the lower court got it right and considered what was in front of it in the skeletal four corners of the complaint, involving just the letter identifying Jean Street and nothing more as far as my home or our house or anything beyond, just a street and the location of the city in general. I believe that's all I have if there's not any other questions.
Thank you, Counsel.
Thank you.
Counsel, before you start, there's one matter I would like to bring to your attention since you're both here. In our record is a copy of the letter that commenced this action, so to speak. I note that it has her social security number listed there.
Oh,
It has not been redacted.
Okay.
It has been now. I issued an order to do so because I
Okay.
think they're entitled. But as you prepare your record in the future, that may be something that, I know you
Got it.
got so much on your mind, but that may be one more thing to add on to your list.
Okay, got it. There's only 2 points that I want to make. The first is there's been some argument about the prejudice that the city suffered. Keep in mind that an inability to get fresh evidence. The statute gives you 3 years to file the notice of claims. So to the extent that the city wanted to go like the following week and take pictures, they were never entitled to do that in the first place. And the second point, which I think you pointed out, was that HSN actually found the statute or the notice of claim sufficient. So I don't think it's actually a case in favor of the city. It's a case in favor of us. So that's our case.
Okay.
Thank you.
Thank you. Thank you both.